Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. Watching the NBA Finals on your smartphone at work? Not willful disobedience of work rules for the purposes of unemployment compensation, according to the Pennsylvania Commonwealth Court. In a recent Commonwealth Court opinion entitled Gordon Terminal versus the Unemployment Compensation Board of Review, written by the esteemed and learned Judge Kevin Brobson, the court affirmed the Unemployment Compensation Board's decision affirming the unemployment comp referee's award of unemployment comp benefits to a worker who was terminated from employment for using a smartphone on the job to watch the NBA Finals, the Super Bowl, and other television programs. Now, the employer terminated the worker's employment on, among other grounds, the fact that he used a smartphone at work in direct violation of a workplace rule and despite receiving a written warning concerning same. The now former worker filed for unemployment comp and the employer objected. The employer in the UC case was attempting to prove the worker committed willful disobedience of a work rule. If the employer had succeeded, UC benefits would have been denied. The employer bears the burden of proving that the worker's unemployment is due to willful misconduct. Now, what does willful misconduct mean? Well, the UC statute doesn't define it, so we must look to the courts. And the courts define it as follows, one of four definitions. 1, wanton or willful disregard of an employer's interest. 2, deliberate violation of an employer's rules, and that's what the employer in this case used. 3, disregard for standards of behavior which an employer can rightfully expect of his employees, and 4, negligence, indicating the intentional disregard of the employer's interest or an employee's duties or obligations. Now, the case law also states that the employer seeking to prove willful misconduct by showing that the worker violated the employer's rules must prove the existence of the rule and the violation. Now, where an employer however, admittedly tolerates violations of its rule, an employer then may fail to establish willful misconduct, and that's how the employer lost this case. During the UC hearing, the worker testified that he's not the only one on their phone in the employer's plant, and everybody in the plant is on their phone. And he also is being singled out. He testified, and we watched the Super Bowl and numerous other games, including the NBA Finals, and that everybody in that section has their phones at all times, and they're constantly on their phones. The worker even testified that the supervisor who fired him for being on his phone had previously come over and sat there and watched a game with him on his phone. Now, the worker testified that as for smartphone usage, if they were going to fire someone for using it at work, they would have to fire everyone, including a supervisor. The employer's own witness admitted that others had used cell phones in the workplace without being discharged, and that testimony by the employer's own witness proved to be devastating to the employer's case. Now, also during the hearing, the worker acknowledged that he was aware of the memo posted on the employer's bulletin board stating that use of smartphones was not permissible without special approval, and they didn't have special approval. He also admitted to receiving a letter from his employer regarding a similar earlier infraction, but explained he hadn't received the letter until the employer showed it to him on his last day of work. But in any event, neither the posted rule on the bulletin board nor the written warning letter saved the employer in this case. The board found that it was common practice for employees of the employer to watch sporting events and other things on their cell phones. Thus, the board found that the employer engaged in inconsistent enforcement, and that's the key phrase, inconsistent enforcement of the work rule. And as such, the employer did not establish the existence of a rule that could support a finding of willful misconduct. The Commonwealth Court affirmed the board's decision, and the worker got his unemployment comp benefits. Now, the lesson for employers: if you intend to terminate the employment of a worker for a violation of a work rule and wish to defeat his subsequent claim for unemployment comp, you had better make sure you consistently enforce that work rule against all other workers. Well, that's about all the time we have today for the Scaringi Law Lunch Break. I hope you learned a little bit about the law. If you have any questions about employment law, call us here at 717-657 7770. Thanks for listening and enjoy your lunch.